Good afternoon, everyone. Thanks for joining us. I'm thrilled to be joined today by Michael Doherty, the elected DA for the Boulder County DA's office. We're going to get right to it in just a moment, but I have two announcements for you. This is Kirsten Logan. I'm the training coordinator with COVA. There is a copy of the presentation in the handouts tab, and you'll want to download that during the webinar. Also, you should get an email later today that confirms your attendance at this webinar. Please save it for your records. And if you are applying for COVA Victim Advocacy Certification, submit it with your packet. If you're watching this webinar online later, we hope you find it helpful, but please note that archived webinars cannot be used for COVA Victim Advocacy Certification. And my contact info is in the chat box if you have any problems downloading the handout or with the email. So with that, I'm gonna go on mute, and if you have questions, just go ahead and type them in. Mike will have a couple pauses during the presentation where he'll be able to take some questions. And if you need anything, go ahead and send a chat directly to me. With that, I'm going to mute and turn it over to Michael.
Well, good afternoon. My name is Michael Doherty, and hopefully, and Kirsten can confirm for me, you could see the first slide of the PowerPoint on the screen. Kirsten, can you see that?
Indeed. I love it when this stuff works.
That's great, but now you've jinxed us for the rest of the presentation, but we'll hope for the best. So good afternoon, everyone. I'm excited to be with you today to talk about Senate Bill 217, which is entitled the Bill to Enhance the Integrity of Law Enforcement. I appreciate taking the time to join us to talk about this important legislation that just passed in this most recent legislative session. I'm going to talk to you about a little bit about the background and then some of the provisions that are going into effect this year or have already gone into effect. But I'd like to start by just talking a little bit about this bill and why I think it's so important for all of us as we live through an incredibly difficult and challenging time in our country, in our state, and in all of our individual communities. You know, one thing when I think about Senate Bill 217 that I'll share with you is that as a prosecutor, I'm very mindful of the fact that we can only ensure public safety, which is our top priority, if we have the trust of the community. As a prosecutor or an investigator or a victim advocate, we've all seen cases where people don't believe or trust that the system is going to work for them and be fair. And as a result, that has a very practical impact on us in the criminal justice system, where we'll have cases, such as a case I had many years ago, but it stays with me to this day, where there are about 50 people in a bar and a fight broke out. And as happens when there's a fist fight, everybody turned to watch. Part of this was captured on video. During the fight, someone pulled out a handgun and fired multiple shots. Those shots hit a bouncer who was trying to break up the fight. He survived, and everybody fled from the shooting in the bar and went outside. The number of witnesses who cooperated with that shooting investigation was 0, including the victim, who, when I visited him in the hospital, told me, "Don't worry, I'll just take care of it myself." I said, "You know what? Now I'm very worried." But he wasn't persuaded by what I told him the criminal justice system could do. And as a result, that gun remained out there. The perpetrator was never brought to justice. The victim and his family and loved ones never had any form of closure. And we weren't able to do anything with that case. That case remained open when I moved to the great state of Colorado because there was a lack of trust in the criminal justice system. To me, we're at a time in our country where we have to recognize that there are people in the community who do not trust law enforcement, do not trust prosecutors, don't trust the justice system to work for them and be fair and to do justice for all. So there are parts of Senate Bill 217 that one may disagree with or feel very opposed to, and I respect that people have different views of Senate Bill 217 and the different things that went into it or came as a result of it. But I hearken back to that trust, because that to me is something that grounds us in the criminal justice system, including for public defenders and defense attorneys, that if people don't trust the work we're doing, when the system doesn't work, we don't have people call 911, cooperate as witnesses, come down to the courthouse, or if there's a juror coming in, potential jurors aren't inclined to believe certain people in the courtroom, it makes it a lot harder for the system to do what we're supposed to do, which is to do justice. So with that in mind, I'm going to start talking about Senate Bill 217. And as Kirsten pointed out, there'll be different points here where I'll stop and take questions, or Kirsten will ask a question if it's being put in the chat box and I don't spot it. But I really encourage you to let me know if you have questions. I will talk to you a little bit about the background of Senate Bill 217, because it's particularly interesting to look back at this year and think about how things developed. And when I think about Senate Bill 217, I think about it in some ways as the product of the storm, the perfect storm, because due to the coronavirus, the legislature suspended operations from the middle of March till the middle of May. So they were not in session when they would normally be in session all the way from January through May. Rather, they were coming back after that suspended period due to the pandemic and continuing the legislative session. Before the session had even started, so before January, there were some legislators, and this has been publicly reported, and I could tell you from conversations with them, that they were focused on police reform, law enforcement reform efforts. But a bill had not been introduced for a variety of reasons. However, when the legislature came back into session after that period of suspension, which but for the pandemic would not have happened, following that, George Floyd was murdered in Minneapolis, and it was captured on video in broad daylight, and it had an impact on so many people and communities throughout the country. And we've seen deeply felt expressions of anger, rage, sadness, and demands for reform as a result. The Colorado legislature was in session during this time, and their response was to revisit some of the ideas they had been focused on before the session and to put forth a bill, Senate Bill 217, that they thought would capture the reforms that they want to see enacted for the entire state of Colorado. The first version of that bill was a rather extreme, more extreme version of the final bill that was passed. That first version drew a lot of attention from law enforcement and caused, I think it's fair to say, a great deal of anxiety in the law enforcement community about the impact that it might have. There are about 140 amendments introduced over the next 2 to 3 weeks. Most bills, as you may know if you've been down in the legislature, are introduced, and then there's 3 to 4 months of discussion, study, analysis, testimony before a bill ends up either passing or not, and if it passes, moving on to the governor's desk. This happened in such a fast-paced period of time, and it was a very rushed effort with a lot of people giving their very best to it. But still, when you have legislation that moves through the process very quickly, there are some confusing pieces that result, and certainly that's true with Senate Bill 217. Some of the provisions of the bill have a direct impact on law enforcement, and by that I mean will change law enforcement operations and already have started to do so. Other sections were put into the law, and many agencies may already have these things in policy. So for example, I'll touch on this as we go through the presentation, but there are some provisions of Senate Bill 217 that Boulder County law enforcement agencies already had in their policy. But Senate Bill 217 makes it the law and requires law enforcement to be consistent throughout the state. It applies to peace officers, as you see defined on the screen there. Notably, it includes the chief of police, police officer, sheriff, undersheriff, deputy sheriff, and so on. These definitions are important, and it varies depending on what section of the bill we're referring to. So for example, you may have seen the recent Denver Post article that highlighted that the state legislature did not include certain state law enforcement agencies, including state patrol, in the qualified immunity section because they were concerned about the fiscal impact. And that was in the Denver Post last Sunday. And there were comments about perhaps the need for it to be, if it's going to be a law, that it should be consistent at the state level and the local level. It does not apply to civilian staff at a police department, so that's an important point. If you're in law enforcement and you're watching right now, that you're aware it does not apply to the civilian staff in a law enforcement agency. So as I said, some of the provisions of Senate Bill 217 are already in effect. They went into effect upon Governor Polis's signature. One of the important things to be aware of, is that Senate Bill 217 requires all law enforcement agencies to be trained on the use of force provisions by September 1st of this year. So for example, here in Boulder County, we've offered to all the law enforcement agencies, we have 8 law enforcement agencies in Boulder County, to provide the training for them if they want to do so. And we've been in most of the agencies in Boulder County already, providing trainings to all the men and women within the police department. And we've started doing trainings within the sheriff's office as well. The agencies can do those trainings in-house if they want, or bring in another outside speaker. But for our office, we've been offering these trainings on Senate Bill 217. And certainly for every agency in the state of Colorado, these trainings have to be completed by September 1st, 2020. Actually, that was 2 days ago. I can't believe it's September. So as of 2 days ago, these trainings had to be completed. However, the body-worn camera provisions go into effect in 2023. So I can tell you, having been actively involved in the pending legislation on Senate Bill 217, many of the discussions about the body-worn camera provisions, it was agreed upon that those discussions would be postponed until the next legislative session, because there was so much for the legislature to tackle in a very, very short period of time with 217. And it was generally agreed upon, at least from my perspective, that the body-worn camera section will be revisited in the years ahead. In fact, I know that the members of the legislature, members of law enforcement, and some members of the defense bar want to tweak Senate Bill 217 in this coming session in a number of different ways. So I anticipate we'll see some continued discussion and activity around Senate Bill 217. For purposes of today's presentation, we're going to hold off on talking about the body-worn camera piece. If you have questions, I'm prepared to answer them. But since I do anticipate changes to this piece of Senate Bill 217, I would encourage us to use our time to talk about the provisions that are going into effect in 2020 and hold off on body-worn camera provisions. The only thing I would say about body-worn camera provisions up front is the legislation requires that all law enforcement agencies in the state of Colorado have body-worn cameras by 2023. The legislature decided to hold off until 2023 so that agencies have enough time, whether it be through county funding or through state grants, to secure the funding necessary to obtain body-worn cameras. As you may know, it's not the body-worn cameras that cost a lot of money necessarily. It's the data cost associated with the recording, and then the providing of the recordings, the storage of the recordings, and the providing the recordings to the district attorney's office and to the defense attorneys on every case. So given the cost involved, the legislature decided to postpone the enactment of the body-worn camera provisions until 2023. So let's talk about use of force. The definition of physical force is there on the screen, and the definition of deadly physical force, which has not changed, is there on the screen. And I just wanted to put these on the screen as a backdrop to some of the changes that we'll be talking about as we move forward in this presentation. So we have the same definition for serious bodily injury and deadly weapon, and you see the provisions there on the screen. And I've put on the screen here that deadly weapon means any of the following, which is capable of producing death, or SBI, serious bodily injury, firearm, knife, bludgeon, weapon, device, instrument, and so on, including body parts, which is from the case law around use of force. So it's important to note here that the goal of the legislature was to emphasize de-escalation by law enforcement, so that law enforcement would be mandated to de-escalate situations before using physical means, violent means to effect an arrest, or to prevent an escape, or to stop someone from hurting other individuals or killing other individuals. So you see there provision 1 of 18-1-707. Police officers shall apply non-violent means whenever possible. Before resorting to the use of physical force, the police officer may use physical force only if non-violent means would be ineffective in effecting the arrest, and so on. When physical force is used, a police officer shall not use deadly physical force to apprehend a person who is suspected of only committing a minor or non-violent offense. So let's talk about that for a minute. That's generally consistent with what the law was before Senate Bill 217, but I think it's helpful to take a moment and just think about it. So when physical force is used, a police officer shall not use deadly physical force if it's a minor or non-violent offense. So let's say, for example, we have an individual who's leaving Target here in Boulder, and an officer has reason to believe that the individual shoplifted. The officer starts to approach. The officer tells the individual, "I'm stopping you. Did you take something from inside the store? Did you shoplift?" At this point, the officer is not legally permitted to use deadly physical force. I don't think that comes as a surprise to you, and I think it puts into law how most law enforcement agencies were already operating under the law in Colorado, that you would not use deadly physical force in response to a minor or nonviolent offense. It's important to note that if the individual, the suspect in that scenario, then escalates the situation. So for example, punches the officer in the face, draws a weapon, starts to run, then draws a weapon. Those things obviously vary based on the factual scenario presented. So it can change over time depending on the reaction of the individual. But as a starting point, a police officer could not use deadly physical force to apprehend someone who's suspected of only committing a minor or nonviolent offense. Using a degree of force consistent with the minimization of injury to others, ensuring that medical aid and assistance is rendered to any injured persons or affected persons as soon as practicable. And I will say, as a prosecutor, it's one of the things that's always really impacted or that I've taken note of in my career is how often police officers are engaged in physical altercations with individuals, including shootings, for example, where they immediately turn to rendering medical aid after the threat is addressed. So for example, I had a trial last year. An individual had gotten into an altercation outside a restaurant, ended up shooting another person, and law enforcement responded. And immediately upon putting the shooter under arrest, began rendering medical aid to the shooter and having EMTs take care of the shooter. And that's now not only expected, but required under Senate Bill 217. Also required is that law enforcement ensure that any identified relatives or next of kin who sustain serious bodily injury or death are notified as soon as practicable. For many, if not all, of the critical incident teams in the state of Colorado, so those are teams that respond to officer-involved shootings or fatalities, there are already protocols in place for the team to make that notification with the help of the coroner's office. However, Senate Bill 217, I'd point out for you, extends that to cases involving serious bodily injury. So let's say, for example, you have an individual who pulls a BB gun on a police officer. The BB gun appears to be real. It's one of those replica firearms. The officer shoots the individual in the shoulder, and the individual survives the shooting, and he's placed under arrest or taken to the hospital and placed under arrest. If that qualified as serious bodily injury, then the police are required to notify any identified relatives or next of kin. And law enforcement, my recommendation would be, should document that contact. Effective immediately. Upon signature of the governor, police officers cannot use chokeholds of any kind. You see here on this screen under 2.5a, the definitions of chokeholds. So it means a method by which a person applies sufficient pressure to make breathing difficult or impossible. Also, I highlight for you that the second definition there on the screen under subsection 2 also means applying pressure to a person's neck on either side of the windpipe. So these are the carotid chokeholds. Law enforcement is prohibited from using these chokeholds. So what I've been telling law enforcement in Boulder County is they should not be training on it and they should not be using it. It is prohibited by Senate Bill 217, and it's, as you see there, the language on the slide is directly from Senate Bill 217. So I'm going to stop here for a quick moment. I'm going to turn next, before we turn next to talk about the fleeing felon rule and how that's changed under Senate Bill 217. Why don't I stop and see if you have any questions for me?
All right, we'll give folks a minute to type. This is a listen-only webinar, and looks like questions will likely only come to me, but we'll see if they pop up for Michael too, if anybody's got some.
Kirsten, do we have any questions?
Not seeing any at the moment. I'll let you know if someone was still typing and we can move on.
All right, great. Thank you. All right. Let's talk about deadly physical force and what's commonly referred to as the fleeing felon rule in the state of Colorado. Under the law before Senate Bill 217 was enacted, law enforcement had certain scenarios, certain legal justifications for using deadly physical force in response to what is commonly referred to as a fleeing felon. And although these cases are, if you look at all the officer-involved shootings in the state of Colorado, these cases happen the minority of the time. In other words, most of the officer-involved shootings are not in response to a fleeing felon. But these cases, the fleeing felon cases, tend to drive the most concern and public interest and outcry. And the legislature was committed to narrowing the circumstances in which law enforcement could use deadly physical force in response to a fleeing felon. So as you see there on the slide, the legislature repealed the affirmative defense of physical force in making an arrest or preventing an escape, and replaced it with use of force by police officers, which states a police officer is justified in using deadly physical force to make an arrest only when all other means are unreasonable and all three of the following are in place. So you need all three of the following here for a police officer's use of deadly physical force to be justified under this section of Senate Bill 217. The arrest is for a felony involving conduct including the use or threatened use of a deadly physical force. The suspect poses an immediate threat to the police officer or another person, and the force employed does not create a substantial risk of injury to other persons. So let me use a factual scenario to bring that to reality a little bit and see if you have any questions about it. And let's say I want to differentiate between one that would be justified under Senate Bill 217 and one that would be perhaps unjustified. So let's say under subsection A, it has to be for a felony involving conduct including the use or threatened use of deadly physical force. Let's say you have a gunpoint robbery. The individual uses a loaded firearm, points it at the victim. An eyewitness sees this taking place and calls 911 and tells the 911 dispatcher, there's a robbery taking place, here's the description, the guy has a gun, he's pointing at the victim, and so on. The police pull up, they see the individual, the suspect, with the gun pointed at the victim. The suspect then begins to run. He has the gun in his hand. And as the suspect's running, he turns back and begins to raise his arm to point it at law enforcement. He's posing then an immediate threat to the police officer or to another person. And the police officer points his or her weapon at the individual and fires directly at that individual. Under Senate Bill 217, that conduct in response to that robbery and those specific facts would be justified. Let's change it up a little bit. Let's say you have a robbery case, exact same factual scenario up until the point where the individual calls 911 and reports what's happening. The robbery suspect runs and gets away before law enforcement arrives on scene. 3 days later, law enforcement sees the same individual, the suspect, walking on the street. It's 3 days later. They jump out of their police car, they pull their weapons. The individual does not appear to have a handgun in his hands. There's no firearm that could be observed or that is observed by law enforcement. At that point, the arrest would be for a felony. The felony involved conduct, the robbery, including the use or threatened use of deadly physical force. However, under subsection B, the suspect is not posing an immediate threat to the police officer or to another person. So if that suspect turns and begins to run away, the law enforcement officer is certainly entitled to chase the person and seek to arrest the person for the robbery they're believed to have committed. But the individual is not then posing an immediate threat to the police officer or to another person. So the use of deadly physical force would not be justified under that second scenario that I presented. So what I'm trying to do there, yes, Kirsten.
Sorry, Michael, we do have when you're finished with the scenarios, we do have a question about this section.
Sure. Before I take the question, the goal of the scenarios there is just to highlight that each one of these has to be in place. Each A, B, and C have to be in place for the officer to be justified under this section of Senate Bill 217 using deadly physical force in response to what's been previously referred to as the fleeing felon rule. And we'll talk more about those provisions in a minute, but let me stop here. And Kirsten, what do you got?
The question is there anything written about the use of physical force or deadly physical force when there's no offense, i.e. the police respond for a welfare check?
Well, so if I'm understanding that question correctly, it's that the police officer has no justification whatsoever for the use of physical force or deadly physical force. That's a good question. Is there anything written in Senate Bill 217 that prohibits that? What I would say is Senate Bill 217 explains officers should use nonviolent means whenever possible and can only use physical force or deadly physical force under certain circumstances. So I believe the answer is yes to that question. You won't find anything in Senate Bill 217 that says if a police officer is responding to a welfare check, he or she has or has not the justification to use deadly physical force. But certainly Senate Bill 217 lays out the roadmap that would be followed in analyzing whether the officer was justified or not. In any situation where an officer uses deadly physical force against another individual, under a statute that was enacted in 2015, the law requires a number of things. The law requires that the agency from which the officer is employed, so let's call that the home agency, not participate in the investigation. I think that's incredibly important. The agency for which the officer works should not participate in the investigation because we want to make sure the investigation is independent and has integrity and objectivity in analyzing whether the officer's use of physical force was justified or not. Under that same statute from 2015, there has to be a multi-agency team that responds and investigates the incident. The district attorney's office is then statutorily responsible for reviewing the investigation, conducting an independent review of it, and determining whether the officer's use of force was justified or not, and whether the officer can be proven guilty beyond a reasonable doubt of having committed any criminal offense. As a result of that statute from 2015, the district attorney's office has to publish a written report in any case involving an officer-involved shooting on their website. So you could look on, or you should be able to look on any district attorney website in the state and find what are called decision letters or written reports indicating whether an officer was justified in the use of physical force or not, and the legal analysis behind that decision. And the statute requires that the DA's offices provide those reports, make them publicly available through their website, and that's actually going to come up later on in the presentation as well. So I hope I answered that question. If not, shoot Kirsten another question, please. Kirsten, do you have any other questions before I move on?
Not at the moment.
Okay. Senate Bill 217 requires police officers to identify themselves as a police officer and give a clear verbal warning of their intent to use a firearm or deadly physical force, provided they have sufficient time to give a warning. And if giving the warning, taking the time to give the warning, would place officers at risk of injury or death, or place other people at risk of injury or death, then the warning is not required. Senate Bill 217, however, makes clear that the warning is required if the officer has the opportunity and the ability to do so, to warn an individual that they're about to use their firearm or other physical force against an individual. An important point to know about Senate Bill 217 is that under 4.5, a different section, it states that notwithstanding any other provision in this section, an officer is justified in using deadly physical force if the police officer has an objectively reasonable belief that a lesser degree of force is inadequate. And you can see there on the slide that the police officer also is under the belief, an objective belief, that he or she or another person is in imminent danger of being killed or receiving serious bodily injury. Basically, under section 704, which is the same self-defense law that applies to everybody, including non-law enforcement individuals in the state, this restates the provisions under Senate Bill 704 and applies them to law enforcement as well. So in a case where we have an officer using force or deadly physical force, the law would analyze it under section 707, which are those sections I talked about a little bit earlier that apply solely to law enforcement, and then also under 704, which applies to everybody. So as civilians, this is the law around the use of force, deadly physical force in defense of oneself. Duty to intervene. So previously under the law, there was a crime of duty to report the use of force. This actually, under Senate Bill 217, creates a new crime for failing to intervene. And I'll talk more about Boulder County in a moment. But what this means is that if an officer has reason to believe that another officer is using excessive force, that officer, the one observing it, has to intervene. They have a legal duty to do so. If they fail to intervene, they could and would be charged with a Class 1 misdemeanor that's been newly created under Senate Bill 217. So they have a duty to prevent or stop another officer from using physical force that exceeds the degree permitted. They have to report it within 10 days, and that report must be in writing and part of the case paperwork. In addition, that report has to be made regardless of the chain of command. So if a police officer sees his or her supervising officer, let's say they see a sergeant punching someone in the face and it's unjustified, it's excessive use of physical force, regardless of the fact that the individual using force is the supervisor, that report has to be made. So I want to stress that because I think it's really important for law enforcement, which operates within a chain of command, to be aware that the chain of command does not prohibit or permit, officers to not make this report. So let's stop and give a good example of this so we have a clear understanding of what this requires. Let's say there's a police officer who's just generally frustrated with their day or with current events, whatever it might be. They're angry, they're frustrated, and they're interacting with, we'll put it as a college student up on the hill in Boulder. And the college student mouths off, but there's no threat of physical force by the college student, and there's no justification, and the police officer suddenly punches the individual in the face, and then goes to punch the individual again. Any police officer standing by who sees the second punch about to happen, maybe they didn't know the first punch was coming, but certainly when they see the second punch, they have a legal duty to intervene to any use of excessive force. We've had a question from a number of folks here in Boulder County, so I'll just share with you, and this only applies to Boulder County, about what if we have an Adams County Sheriff's deputy at a bar in Boulder County. He or she is not armed, he or she is under the influence. Would we charge them for failing to intervene? We've told law enforcement here that we're going to hold on-duty officers to this legal requirement. We believe that's the spirit and intent of the law, that officers who are on duty within their jurisdiction and able to respond have a legal duty to do so. Okay. Let's continue with duty to intervene. So I mentioned it's a class 1 misdemeanor. Chain of command is not a defense. So law enforcement has to intervene, report it, and make the written report part of the case file. There's what I would call a whistleblower protection in here under that subsection C, that the agency and supervisors shall not discipline or retaliate in any way against the police officer who makes the report. So let me give you another example. Many years ago, after 9/11, there were vendors who were selling photos of the attack and selling materials related to the attack around Ground Zero. And there was a police officer who took one of the vendors behind a construction fence. There was no one back there. And the police officer handcuffed the individual for what's called unlicensed vending. The individual did not have a license to be selling materials. But the police officer was really just very, very angry that the individual was selling pictures of the attack and selling them by Ground Zero. And the police officer took out his radio and smashed the vendor in the face. Obviously, unjustified use of force, excessive use of force. They then engage in a struggle and they fall to the ground together. If a police officer came across them then, not knowing what had happened and not being aware that the radio was used to smash the individual in the face, that's not failing to intervene. The officer has to be aware that it's an excessive use of force. So let's say the officer had come in, the second officer had come in a little bit earlier, before the, what I'll call defendant officer, hit the vendor in the face with the radio. That would be a duty to intervene at that point, and failing to do so could be prosecuted as a class 1 misdemeanor. A couple more things on duty to intervene, and then I'm going to stop and see if you have any questions about it. So when an administrative law judge or internal investigation finds that a police officer failed to intervene, that finding must be presented to the district attorney's office. So often when officers use force, as you may know, law enforcement agencies have an internal process for reviewing use of force. That's separate from a criminal case, has nothing to do with the district attorney's office, except perhaps under limited circumstances where they believe a crime might have been involved. But let's say here, for example, you have the Longmont Police Department is aware that one of their officers used force in an arrest, and just through their standard protocol, they review it to make sure the use of force was appropriate and consistent with their policy and protocol within the department. Let's say the Longmont Police Department determines, actually, not only was that use of force excessive, there was another officer who failed to intervene. That report must be made to the district attorney's office. And if it involves serious bodily injury or death, it also has to be provided to the post board, and the post board shall permanently decertify a police officer if the officer failed to intervene. So that's a pretty significant thing. Anytime officers hear the possibility of decertification, it's of course very serious. It's career, jeopardizes their career. It's an incredibly important thing for us to focus on. And there are a couple times in Senate Bill 217 where there's references to the post board, which operates out of the Attorney General's office, and whether the post board would or could decertify. And under Senate Bill 217, it actually limits the discretion the post board has. I can tell you that under the current rules and regulations of post, that there are many, many misdemeanors. I think it's over 44, if I recall, and all felony convictions could result, and almost certainly would result, in decertification of an officer. For failure to intervene, the post board does not have any discretion, and the post board would have to permanently decertify the officer, and it can only be overturned if the police officer is exonerated by a court. The use of the word exonerated here is interesting to me. It's not defined by statute in Senate Bill 217, and you'll see it used on another slide as well. Usually we think about the word exonerated as being part of a wrongful conviction analysis. So whether or not this would include conviction being vacated upon appeal, or an officer being found not guilty, I think would be something the post board has to look at. It's not specifically defined here, but certainly the report has to be made to the district attorney's office. And then if it involves serious bodily injury or death, the employer has to also notify the post board, and the post board, if it's proven to be true, would have to permanently decertify the police officer. Keep in mind, however, the circumstances around this are fairly unlikely to happen. So when I talk to law enforcement and I ask them, how many times have you seen a fellow officer use excessive force and you've done absolutely nothing? So you just stood there while the college kid was getting punched in the face over and over and over again. From my perspective, that's a fairly unlikely scenario. And although this puts on officers a legal duty to intervene, I would believe that officers already had a moral duty to intervene, that they would have intervened anyway before Senate Bill 217 required it. It's my own 2 cents there. But either way, under Senate Bill 217 is now a legal requirement that officers would intervene. Okay, requirement on the district attorney when it comes to duty to intervene. Let's stay with that example of the college kid on the hill. Police officer punches the college kid in the face. It's reported. We charge and prosecute the officer, and we do not prosecute the other officer for failure to intervene. If we do not file charges against the other officer for failing to intervene, the DA would have to prepare a written public report explaining the decision not to charge. It's fairly unusual. There's only one other circumstance in which we do that, and that's, as I indicated earlier, under that statute from Senate Bill 2015 on officer-involved shootings. That's the only other circumstance where we're legally required as a district attorney's office to publish a written public report explaining the decision not to charge someone with a crime. I think this speaks to how seriously the legislature took this part of Senate Bill 217 and how important it is. And that report must be made public within a prescribed period of time unless it would interfere with an investigation. All right. We're going to move on to post-certification, but why don't I take a quick minute here, Kirsten, to see if anyone has any questions.
Yeah. Let's see. Here's a couple related to what we just talked about. First, with regard to duty to intervene, charges or cases, do you envision prosecuting these cases or going to trial only after the underlying case, the officer who used unlawful force, has been resolved and ended in a conviction?
That's a really good question. It's certainly not required, and I could foresee circumstances in which we would prosecute an officer for failing to intervene regardless of what happened with the other officer's use of excessive force. In other words, there's no legal requirement, nor do I think there should be, that one be proven before the other. These would be looked at independently. Obviously, the use of excessive force we'd have to believe was present for us to charge someone with failing to intervene, but they need not be charged in a particular order, and we would need not secure a certain result before moving forward with the failure to intervene case.
Okay. Thank you. And then 2 more follow-ups on that. 1, what if the DA chooses not to charge? And 2, would an officer be considered exonerated if the DA chooses not to charge?
Good questions. So if the DA chooses not to charge, and I assume we're talking about the failure to intervene here,
Yeah,
the
that
DA would
was
have
from
to
a couple minutes ago. So yeah.
Okay. The DA would have to publish that written public report explaining the decision not to charge. And I believe then that under these circumstances, the post board would likely have been notified if the police department had determined the individual failed to intervene. In other words, I've gone back to this slide with section F. So let's stay with that Longmont example then. So Longmont PD notifies the post board what they believe is an administrative violation at the very least for failing to intervene. The DA's office has to conduct a separate analysis to determine, whether the charge can be proven beyond a reasonable doubt or not. So I think to answer that question directly, the post board the case would never end up in court because the DA's office would not have filed the charge. So I don't think you get to the exoneration by a court piece, that final line on the slide, since you don't have a criminal prosecution. So I imagine that the law enforcement agency could and would take action for the violations of their departmental policy. The post board could look at it, but I don't think it would require permanent decertification, no.
Ooh, here's another good one. What constitutes intervening or an intervention? A verbal action, or must it be physical action?
Great question. I'll go back and check Senate Bill 217, but I'm 99% sure it's not defined in the bill. I assume it would be fact specific and driven by the circumstances. So in other words, verbal could be enough, but if verbal's not doing it, just my own view of it is then it would require a physical intervention. So college kids getting punched in the face, one officer saying stop, 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 it would require some intervention then to prevent the use of unlawful physical force.
Okay, thank you.
All right. We're going to move on to post-certification. And again, just a little background for those of you not familiar with post-certification. Every peace officer, every sworn peace officer in the state of Colorado is required to be certified by post. That certification is a requirement for them to work for law enforcement agencies in the state. So it's an important thing in the world of law enforcement. There are, last I checked, 44 specified misdemeanors and every felony that if it results in a conviction for an officer, the post board has the responsibility of determining whether the officer should be decertified or not. Just in my own experience, having been the head of the criminal section at the AG's office years ago, I can tell you that I think the vast, vast majority of those do result in decertification. However, you're going to see some words here on the slide that require permanent decertification and limits the discretion that the post board might have in these circumstances. So if a police officer is convicted of a crime involving the unlawful use of force or the threatened use of physical force, or a crime involving the failure to intervene, or is found civilly liable, the post board shall permanently revoke the peace officer certification and cannot reinstate the peace officer unless, and here's that word again, the officer is exonerated by a court. In my view, absent some specific statutory definition, exonerated would be either, since it's after conviction, under that first bullet point, it would be the vacating of the conviction by an appellate court here in the state of Colorado, or found civilly liable. So that would be likely after a civil trial. And again, it would be the vacating of that finding by an appellate court. The post board shall record each decertified police officer in the database and make that database publicly available. And by January 2022, must maintain a database on information relating to an officer's untruthfulness, failure to follow training requirements, any decertification, and any termination for cause. I will share with you that currently under the law, if a police officer is found to be untruthful, the district attorney's office then sends a letter to, let me back up one step. Generally speaking, when it comes to issues of untruthfulness, you may be familiar with what's called a Brady letter. Those are usually issued by the following process. So a law enforcement executive, chief or sheriff, will notify the district attorney that an officer has been found to have been untruthful. It can be triggered by a court ruling or by a finding by the district attorney, but often under the usual circumstances, it comes by way of the law enforcement agency becoming aware an officer's been untruthful. They then notify the DA's office. The DA's office then issues what's called a Brady letter to defense attorneys in their jurisdiction, letting them know that the officer is on what's called the Brady list, that there's an issue with their credibility that rose to the level of untruthfulness. That letter, in my experience, is then provided anytime the officer is endorsed as a witness in that jurisdiction. What this database will do, will share this information statewide, and it also expands the information that's required, including for the training requirements, decertification, and termination for cause. That has to be set up by January of 2022.
Couple more questions.
Sure.
There, Michael. One, if an officer is decertified in Colorado, can they still get hired in another state?
Good question. Outside my area of expertise, it would depend on the laws in that other state. So I'm not sure actually if they'd be able to get a job in another state. I imagine the person's asking because they don't think they should be able to, which makes sense to me. I would expect and hope that the law enforcement agency would do the background check. And in Colorado, there was a statutory change a couple of years ago that allows law enforcement agencies to share information with one another as part of background checks for hiring. And the law enforcement agency would be able to share that information here in Colorado with the out-of-state agency that's considering the person for hire. But I think it would depend on the state law in that respective state.
Okay. Another one popped up. So what constitutes a certification of a police officer? What's the criteria?
Oh, good question.
About being decertified, so yeah.
Right. So certification of a police officer, I will say the best source of information on this is available on the Attorney General's website. So the Attorney General's website has a link to the post manual. And if you're interested in diving into the details of this, I'd encourage you to look at the AG's website for the post manual. I will say, and again, you're gonna have to check the post manual to verify this, but for post certification, it's the completion of an academy. The police academy requires training on the law and also police protocol and procedure. You have to complete the police academy successfully, pass it, and then be sworn in as a law enforcement officer after a field training program. So it's a really rigorous program. It goes on for weeks and weeks and weeks. I'm trying to remember, I want to say 40 weeks, but I'm not sure about that. But if you check the post manual, you'll see it's a pretty extensive process, and then the officer is sworn in as a peace officer and certified.
Cool. And one more popped up. Does civilly liable include federal court? Does it include a police chief or agency head who's held liable under a pattern or practice theory?
It's a good question. So for civilly liable on this, with regards to this provision, it's civilly liable for the use of unlawful physical force or failure to intervene. So it would apply to any level within a police department, including the police chief, but it would be specifically with regards to unlawful physical force or failure to intervene, as for this section. Pattern and practice in Senate Bill 217 is addressed in another slide that we'll get to, but does not require immediate decertification of the officer. But I would have to check further on that. And if you want, I'm going to give you my contact information at the end. I'm happy to do a little more research on that.
Great, thank you.
Okay, qualified immunity. Before I turn to qualified immunity, I'm not a civil attorney. I'm not an expert in this area. I want to address it just to make sure I do my very best to hit on the major provisions in Senate Bill 217. But if you're a member of law enforcement or you're particularly interested in this issue, I encourage you to talk to a civil attorney or someone who works for a city attorney or county attorney's office, because they'll be dealing with these as opposed to a district attorney. The district attorney's office has jurisdiction over any criminal offense. So qualified immunity, any civil suit that implicates immunity or lack thereof is outside of the area that I practice in. So it's outside my area of expertise. But I'm going to hit on it and do my very best to answer any questions you have, and then we can go through it. But again, if you're a member of a law enforcement agency and have questions for this, we've been training the Boulder County law enforcement agencies. I've encouraged them to contact civil attorney and then city or county attorney, depending on whether they're a city agency or sheriff's department, which would use the county attorney's office. Most importantly, what I would stress as I turn to qualified immunity is law enforcement agencies should have a plan in place in terms of what the rules of the road are going to be, who's going to be part of the review, who's going to make some of the determinations that we'll touch on. This went into effect immediately upon the governor's signature, and you heard a lot of news about this one. It's a particularly important one for law enforcement. Under the law enforcement had what was called qualified immunity, which was they had immunity if they had good faith, reasonable belief that they were not violating someone's constitutional rights in the actions they were taking. And this piece of legislation makes qualified immunity no longer a defense to liability, and officers could be sued individually and could be held personally liable if, and this is an important if, it is determined that the officer did not act upon good faith and reasonable belief that the action was lawful. If that determination is made, the officer is then liable for up to $25,000, civilly liable, or 5% of the civil judgment, whichever is less. Here's an important part to be aware of. The police chief, sheriff, it's actually defined as employer under Senate Bill 217, makes the determination of whether an officer acted in good faith and with a reasonable belief that the action was lawful. That's a really important point for me to emphasize, because when you see the word employer there, it can mean different things. It can mean the elected sheriff for the sheriff's office. It can mean the county commissioners for the sheriff's office, or some hybrid of the two. It could mean, within the world of a police department, the police chief alone, or city council, or some hybrid where you have a panel set up with a city attorney, city manager, and police chief. However it's set up is going to be up to the individual agencies and jurisdictions, but they're going to have the responsibility, the legal responsibility, to make a determination of whether the officer acted in good faith and with reasonable belief the action was lawful. If they did, and that's an if, but if they did, then the police agency shall, under Senate Bill 217, indemnify the officers for any liability of judgment. This slide just references that in any action, a court shall award reasonable attorney fees and costs to the prevailing plaintiff, so the individual suing the officer. And the court can deem a plaintiff for prevailed if the plaintiff's suit was a substantial factor in obtaining the results sought by the litigation. Similarly, there's a provision in Senate Bill 217 for the defendant officer, so the individual who's being sued, the police officer, to seek reasonable cost and attorney fees if the court finds the suit to have been frivolous. Protests, this is effective immediately. So my recollection of this is while Senate Bill 217 was going on, there were a number of protests and marches in Denver. The response of law enforcement to those protests and marches certainly got the attention of the legislators, and this was then added in, that's my recollection, to Senate Bill 217. Whether that recollection is correct or not, the law now states that in response to a protest or demonstration, law enforcement agencies shall not discharge any projectile, including less lethal projectiles, in a manner that targets the head, pelvis, or back, or fire those indiscriminately into a crowd. And if law enforcement is going to use any chemical irritant, such as pepper spray or tear gas, prior to the use, law enforcement has to make an announcement to disperse, and do so with enough time and space for individuals to comply with that order before the use of chemical agents, including pepper spray and tear gas. That is already in effect, so law enforcement should be aware of it, because it's certainly a requirement under Senate Bill 217. Contact with members of the public, and I know I only have a few minutes left, so I'm going to speed up a little and then I'll stop and take questions at the end. Under Senate Bill 217, law enforcement has to have a legal basis for making a contact, which is true already under the law, whether consensual or non-consensual. After making a contact for purpose of enforcing the law or investigating possible violations, law enforcement has to document the following data from that contact. Interestingly, under subsection A, the officer has to note the individual's perceived demographic information. So in other words, law enforcement has to make a best determination as to the individual's race, gender, and so on. They can be assisted by, if they're looking at a driver's license, for example, or if they run a computer check on a person, that information might be available to them through those sources. However they gather that information, including just their own perception. So there's the possibility of this being difficult for law enforcement and difficult to check the data, but it has to be what they perceive as the demographic details of the individuals they stop, traffic stop, time and date, duration. And then you see here the other data that has to be collected: the reason, suspected crime, result of the contact, and then any actions taken by the officer during the contact. You see under section H there a variety of things. I would point out it also includes if the officer has unholstered his or her weapon, and whether the officer, of course, discharged their weapon during the contact. Use of force data collection also has to be taking place now. Much of that same data is captured under the stop contact section that I just went through. Under the law, under my reading of Senate Bill 217, law enforcement officers are supposed to be collecting that data now, but the bill as written requires law enforcement to start reporting it to the state Division of Criminal Justice in January of 2023. And if I recall correctly, that's so that they have a system set up to take all that information from law enforcement and then be able to make it available to the public. So the collection of the information should actually be starting now at the agency level, but not reported to the state until January of 2023. So if you're in law enforcement and you're listening in today, I'm confident that DCJ will be providing direction to law enforcement, and there'll be communication back and forth about how this information is to be collected, how it's to be reported, and so on. At the end of each traffic stop, when there's not a ticket or an arrest, the officer or deputy shall provide a business card. Again, this is if the person didn't get a ticket or an arrest. And the business card has to include identifying information about the officer, as well as information about how to file a complaint related to the contact. And that information must be kept confidential by the agency if a complaint's made, unless and until it becomes necessary to share it to the extent permitted under law. So this is absent a ticket or arrest. This is my last slide, and then I'll stop and take any questions you have. I was going to tell the story about when I got my first speeding ticket, but we'll save that and see if we have time at the end. If the district attorney, so let me back up one step. Prior to Senate Bill 217, if a district attorney presented a case to a grand jury involving an officer-involved shooting, the grand jury had the discretion, if they didn't vote to indict, so they didn't vote to charge the officer, they had the discretion to issue a report, a public report. That report would then be provided to a judge, the grand jury judge, who would have the discretion to release the report to the public or not. This takes away that discretion and makes it more consistent with the DA's obligation under that 2015 statute that we talked about a little while ago. So if a district attorney refers an officer-involved incident to a grand jury, the DA has to release a statement at the time, this is under the statute from 2015, that the matter is being referred to the grand jury. So for example, let's say our office is putting an officer-involved shooting in the grand jury, which we've done. I have to make an announcement to the public at the start, letting the public know the matter's been referred to the grand jury. Now here's the part that changes under Senate Bill 217. If no true bill, no charges are returned, the grand jury shall issue. It's not a matter of discretion. The grand jury shall issue and publish a report, and the judge has to allow the report to be published. So this takes away the discretion for the grand jury and the court, and as I say, makes it more consistent with the current statutory obligations of the district attorney. Also, I'll just quickly hit on this Senate Bill 217 allows the Attorney General for the state of Colorado to civilly enforce the requirements regarding public integrity, what's commonly referred to as pattern or practice, which for many years has been within the power and responsibility of the federal government. Now our state Attorney General has the power and responsibility to investigate pattern or practice violations and to take civil action, not criminal, civil action in response to any finding of a violation. Also, the Attorney General can bring a civil action for any agency hiring or retaining a police officer in violation of post-certification and rules. Okay, so I'm going to see if I could stop sharing my screen, and at the very least, I don't know if you could see me or you could see the GoToWebinar slide up there, but either way, I'm happy to take any questions that folks have, Kirsten.
All right. Yeah, we are still connected to GoToWebinar, so yay. Excellent questions. We'll go back through and see if we've skipped any, give folks a chance to type.
So while you're doing that, I'll tell you that I'm going to confess here. So a year and a half ago, 2 years ago, I'm driving by myself, flying through And there's the confession, the flying through part. Alamos, I'm in the valley, and I see a sheriff's car approaching. And as you may or may not know, they have the capability to capture speed while in motion with a radar device that's on the front of the police car. I was reminded of that when I saw the sheriff's deputy turn around, turn on his lights and siren. And I pulled over and I rolled down my window. A beautiful morning. It's like 7 o'clock in the morning on a Sunday. And the sheriff's deputy comes alongside. It was like a scene out of a movie. He's huge. He's got these dark sunglasses on. He's like towering over my car. And he says, "License and registration." I said, well, listen, I'm going to give it to you, obviously. But if you give me a ticket, you're going to break a 30-year streak. I've never been pulled over and I've never gotten a ticket. And he looks at me and says, "The streak is broken today." So I get my license and registration. The streak was broken that day. I got a speeding ticket. And then after I had the ticket in hand and already had the ticket, then I disclosed that I was a district attorney. We had a great conversation along the side of the road, and I was more than happy to plead guilty and pay the fine via mail when I got home. That's the one time I've gotten a speeding ticket. That's my confession.
Well, and we always had to report if we got a ticket up the chain. So as the elected, who did you have to report your ticket to?
I think I confessed to multiple people in the office. Actually, it was a good opportunity, Kirsten, to reinforce that we should never identify ourselves as a prosecutor, and because whether it's real or perceived, the impact that might have on an officer's discretion is completely inappropriate. So we would never want someone in our office saying, "Hey, listen, I'm a DA." That's why I waited till I had the ticket in hand before I said I'm a district attorney.
Absolutely. Well, it looks like there are no further questions. Michael, thank you so much. And we hope everyone has a great and safe afternoon.
Kirsten, I'll just quickly give my email in case people want to reach out to me. It's mdoherty@bouldercounty.org, mdoherty@bouldercounty.org. My direct line is 303-441-3798. We've covered a lot in a short period of time, so if you have any questions or if you want to talk about it further, please don't hesitate to reach out to me. This is an important piece of legislation, so I really appreciate Kirsten and COVA putting this together. I'm a proud board member of COVA, and I look forward to continuing to work together to make sure the justice system is operating as well as it possibly can. And I think we're going through a very challenging time, but I remain really excited and hopeful for the future. So please feel free to reach out to me if you have questions or you want to discuss any of this at all. And I really do hope you have a great day. Thank you.
Perfect. And for those still on, Michael's email is in the chat. Thanks, everyone. Be well.